can hear me, right?
I can hear you very well.
Sorry for my technical issue. Hi, everyone. I'm Siyi. Now I will share my screen. Hi, everyone. Today my presentation topic is the role of the law of unjust enrichment in China. And as you can see here is the structure of my today's presentation. I think now is really a good timing for discussing the Chinese law of unjust enrichment. As Professor Liu just mentioned, that we now have a new civil code. So in my presentation, I will discuss both the law of unjust enrichment just before the civil code and in the new civil code. And I will discuss whether there is any change in the role the law of unjust enrichment plays. So first, before the civil code, when we only have one legal provision, that's Article 92 of the General Principles of Civil Law, which was called as mini civil code in China. And it says that if a person obtains unjust benefits without legal basis and resulting in another person's loss, he shall return those unjust benefits to a person suffering a loss therefrom. And except for this one, we have a judicial interpretation, and it regulates the scope of the return obligation of unjust enrichment, which should include original object, original thing, plus fruits. It also says that other interests shall be taken over by the state after deducting the stable service overhead. This other interest requirement is kind of strange, as like the state kind of intervene into this civil relationship, and it's some kind of like socialism impact on the legal system. And as no further explanation given on this one, I won't discuss this further. And then let's discuss the Chinese Civil Code, which just passed last month, and it will only be effective on 1st January 2021. And here is the structure of our new civil code. Unjust enrichment, as mentioned, is regulated in Article 1 to 2. Here is the new provision. I think this has already been mentioned by Professor Liu, and it's nearly a duplicate of Article 92 of the GPCL, but I do spot a subtle difference between these two provisions. The constitutive elements of unjust enrichment remains the same in China. However, the new provision, the Article 1 to 2, make unjust enrichment more like granting a right to the favor to the person who suffered loss due to the unjust enrichment, because he has the right to require the return. However, originally we have the wording in Article 92. It's more like a liability. The person who unjustly enriched shall return those benefits. So that's the difference. And we have another chapter entitled titled Unjust Enrichment in sub-book 3, quasi-contract, in the book 3 contract. And it's kind of strange why unjust enrichment is placed in the book 3 contract. And I want to discuss those provisions first, and we will get back to this issue later. Article 9, there are in total 4 provisions in the new chapter of unjust enrichment in the Civil Code. Article 9A5, named definition of unjust enrichment, it kind of repeats the Article 1 to 2 again, but it carves out 3 circumstances under which the favoree bears no obligation to return if the plaintiff made the performance to enrich the defendant to fulfill an obligation, or to repay an undue debt, or the plaintiff has had knowledge before that he or she is under no obligation to enrich the defendant, but still did that. So it kind of provides the defenses to the defendant. So in these 3 circumstances, no obligation to return. Then we have Article 9A6 and Article 9A7, which differentiate bona fide favorite and mala fide favorite. So those bona fide is persons who did not know or should not have known that the obtained benefits is without legal basis. Otherwise, he's a mala fide favorite. So for those bona fide recipients, if the obtained benefits does not exist anymore, then there's no obligation to return. But for mala fide favorite, he should always return the unjust benefits and compensate for the plaintiff's loss. So it means even if the obtained benefits does not exist anymore, the mala fide favorite still need to compensate the plaintiff's loss. And Article 9AA clarified the obligation of a third party, says that who gratuitously receive those obtained benefits from the favorite, then still bear an obligation to return to the corresponding extent. So my question to this new provision first is that, is this new chapter of unjust enrichment an improvement to our Chinese law of unjust enrichment? Because before we only have those that one abstract notion of unjust enrichment, so there are a lot of criticisms that this deficient regulation cannot regulate the unjust enrichment area well, and we have a lot of problems in judicial practice. The new provisions do address several problems in this area of law to make it like more fair in practice. However, why only these 4 problems? What about other problems? The one as mentioned by Professor Liu, that how to prove without a legal basis. Should we follow the typology, performance, and non-performance based unjust enrichment, and to dispute and to distribute the burden of proof, or how should we require those plaintiffs to prove the defendant has no legal basis to obtain the benefits? And also how to determine the value of an enrichment. If it can be returned, then we don't have this kind of problem. But the new provision only said that if those benefits does not exist anymore, then there's no need to return for bona fide favorite. But what if the enrichment still exists? Like if A accidentally decorated B's house and the value of the house increased, we can say that the decoration still exists, the enrichment still exists, but cannot be returned directly. So that we have a problem how to value it is be allowed to subjectively evaluate the enrichment. Also, as I mentioned before, we had the interpretation says that the return should include the fruits. Then after the new Chinese Civil Code came into effect, the interpretation won't be valid anymore. Then how about the scope of the return obligation? We still have a lot of problems that haven't been solved, and the new provisions also bring new problems. So the question, why the legislator chose to come up with this new chapter of unjust enrichment? I think I haven't done like enough research on the legislation process, but my feeling is that based on my research on the history of unjust enrichment in China, these are not new provisions. Those provisions have appeared for the first time in China in the draft civil code of Qing Dynasty. So that's more than 100 years before. And also they appeared several times in different draft civil codes before in China's previous attempt to draft the civil code. So it means the legislator probably did not do enough research and to think about unjust enrichment in our current context and to absorb those new research done by our by our Chinese scholars. So I think that the result is kind of disappointing for scholars researching on Chinese law of unjust enrichment. So how about the role of unjust enrichment in China? Before the Civil Code, we have Article 92, which is put in Section 2, obligatory rights in Chapter 5, Civil Rights of the GPCL. So from the place of Article 92, it's obvious that it's taken as a causative event giving rise to obligatory rights. And we have other provisions in this section 2, obligatory rights, which regulate like contract and negotiation gesture. However, with only one abstract notion of unjust enrichment, it cannot be viewed as an independent branch of the law of obligations like contract or tort, and also without a legal basis as a negative fact. Actually, if you think about it, whether an enrichment has a legal basis is decided by other areas of law, never by the law of unjust enrichment itself. So in my research, I follow the typology, performance-based and non-performance-based unjust enrichment, and I list like core scenarios of unjust enrichment, and found out that in most scenarios, the person suffering a loss has the right to require the return of the benefits based on other areas of law, and also other areas of law provide like stronger or more detailed rights or regulations for this kind of return of benefits. For example, if today you take my laptop and I will say give it back because it's my laptop, I won't say give it back because you are unjustly enriched by taking my laptop. It's also because that's my property rights and it's stronger than an obligatory rights. But I did identify several scenarios. In those scenarios, the law of unjust enrichment provides the only legal basis for the return of those enrichments. So my conclusion would be law of unjust enrichment is a catch-all provision. So it's taken as a last resort where other areas of law fails to reverse those benefits. Then we use the law of unjust enrichment. And I got a further conclusion is that for those scenarios where the law of unjust enrichment is the only basis, I call it gap scenarios. Actually, it can be better dealt with by other areas of law because, as mentioned before, like I think by our different speakers, for the consequence of, for example, for the consequence of a terminated contract or void contract, actually in contract law we have very detailed regulation on this point. Then why we need to refer to the law of unjust enrichment? We can use that area of law. And also for those gap scenarios, I also came to this conclusion. If we revise a little bit, then we can cover all the scenarios. We won't need a law of unjust enrichment. And is my conclusion changed by the Chinese Civil Code? Let's take a look. We have Article 1 to 2 also in the chapter Civil Rights. So, and also Article 118 made it very clear that unjust enrichment is a causative event triggering obligatory rights. And we have this chapter 29, unjust enrichment, which put weirdly in the subchapter 3, quasi-contract. And why quasi-contract? What does that mean? I think it's taken as this term derived from Roman law originally. But I think Chinese scholars, based on my research, they agree the legislator suddenly come up with this ideal, this term, in this new civil code because they refer to the French civil code. And in French civil code, actually quasi-contract means an act triggering like kind of obligatory rights without an agreement. Is a kind of, as I can see, like undertakings formed without an agreement. So it's not taken as a subconcept of contract. So although in Chinese law, in the civil code, unjust enrichment chapter is put under book 3 contract, it doesn't mean it has it's a kind of quasi-contract, different kinds of contract. It's just because there's no general part of the law of obligations in our civil code. So you can see there's no place to put the law of unjust enrichment. And the legislator decided to put it into the Book 3 contract and make Book 3 contract playing the function of the general part of the law of obligations. So has the role changed of unjust enrichment in Chinese legal system? I don't think so. Because you look at the provisions, you'll find the new chapter does not change the notion, the principle of unjust enrichment. It's more like specification of those liability, provide defenses in different circumstances, and also clarify the third party's liability. So unjust enrichment. So my analysis still apply. I can still list all those scenarios and find out most scenarios applied adjusted by other departments of law, and we only need law of unjust enrichment as a catch-all provision as a last resort. And what's more, I even find that the new chapter of unjust enrichment make my conclusion even more feasible, because here is the gap scenarios I identified before in my PhD research. You can see there's 6 in total, and most enrichment involved its services. Also, we have money because we have one particular principle of money in China in judicial practice, but most related with services. Because those are things you cannot return directly, so no property law can use it to protect the rights. And in Article 986, it says that the obtained benefits does not exist anymore. In these circumstances, there's no obligation to return. So in some of my gap scenarios, now we don't need to adjust it because there's no need to return. So with this narrowing down of the gap scenarios, I only need to revise other other branches of law to a less extent and to cover all the scenarios. Still, we come to the same conclusion that it's not really necessary to have the law of unjust enrichment, and there's another way forward, another solution for this. So that's all for my today's presentation. Thank you for listening.
Thank you very much, Dr. LIN Siyi. Thank you for your very careful and thoughtful reading of the new civil code and your view on the law of unjust enrichment in PRC is known to be very bold, but I think that also served the purpose of this conference very well, which is to provoke further thinking on that kind of